Oh, you know what? I don't even think I got my microphone. Can y'all hear me? Let me turn it up. Can you hear me? Listen, I was sitting here reading the stuff and I just felt like talking about it. I just felt like I wanted to talk to people about this situation. Okay. So listen, child, because Canton is doing what Canton does. So hello, as all of you pull in here. Let's talk about it. So if you aren't aware, no, so there was no Karen Reed hearing today. I'm a little congested, so just bear with me. Okay, so there was no Karen Reed hearing today, but Judge Bev ruled on she issued her orders regarding some of the latest and last motions for the trial. Tomorrow, of course, is the first day of jury selection for this trial. So we still got a while before it's going to be a couple weeks before we actually get to testimony. But Bev issued some orders regarding, stuff that's been happening. Yes, Blue, that's probably accurate. I had some drinks and then I had more drinks. I had drinks over the weekend and now I'm a little congested, but just bear with me. So and if you watch my last episode of our podcast, The Debrief, we talked about this third party culprit defense, right? And so maybe I'll do a poll since I'm live with y'all. But if you watch Karen Reed 1.0, you know that while the Commonwealth is saying that Karen Reed killed John O'Keefe, the defense is saying, no, she didn't. What they're saying is that Brian Albert, Brian Higgins, and Colin Albert are the ones that killed that man. And so what they did during Karen Reed 1.0 was, while the Commonwealth was trying to put on their case to show that Karen Reed was responsible, the defense was essentially putting on their case to show that Brian, and Colin were responsible. And so Hank Brennan, the Commonwealth, the prosecutor, filed a motion to basically say, hey, Bev, don't allow them to put on their case. Okay. It's called third party culprit. Don't allow them to do that. All that extra stuff, they shouldn't be allowed to enter that into the case. And so what, I'm going to pull it up because it's only like 4 pages. But what Auntie Bev ruled today is that in regards to Colin, they cannot, and for third party culprit, they cannot include him in that. They can do both the Bryans, but they can't do Colin. So we should just look at it real quick because it's not a lot. And I think, and let me tell you, shout out to all the Twitter folks that are obsessed with this case and go and get the documents so I don't have to, because usually any documents I pay for, these people own it. And so you are appreciated. So I'm going to use one of the ones who paid for this already. Here we go. Come on, new member. You see it. T. Kendrick Hall, you see it. Thank you for joining. Okay, so hold on. I have something up. So as we see, right, it's the motion in limine to preclude the defendant from raising a third party culprit defense. And what she says at the end of this first paragraph, the defendant has alleged 3 potential third party culprits, 3 people who are responsible. That's what that sentence is. Brian Albert, Brian Higgins, Colin Albert. So Bev is saying, for the reasons that follow, the Commonwealth's motion is allowed in part and denied in part. Some of them, I'm going to let you rock. The other one, I ain't going to let you rock, essentially. And so what she says, and if there are any attorneys in here, because y'all know I'm not a lawyer, but one of the things that is interesting to me is, hold on, is it this part? The opportunity to present third-party culprit evidence is guaranteed by due process, and basically it's your right. You can do that. I'm going to keep going because I don't want to read the whole thing. Evidence that a third party, this is just a synopsis of it. It's evidence that a third party committed the crimes charged against the defendant or had the motive, intent, and opportunity to commit the crimes is admissible, provided that it has substantial probative value and will not tend to prejudice or confuse the jury. You know, my opinion is that I think it gets confusing. But again, it is third party culprit is basically saying there's a third person here. There's somebody you guys are not considering that committed the crimes that you're charging me with. That's the premise of it, right? And so what she says here, as to Colin Albert, the defendant's proffer contains no additional evidence than that presented at the first trial. So when they tried to make their argument as to why they should be allowed to, she's saying, y'all didn't say nothing else. That was nothing more than you said in the first trial. And it is insufficient to support a preliminary finding that Colin Albert had the motive, intent, and opportunity to commit the crime. Okay, before I continue on, I just want to say something. Okay, and if you're an attorney and you have an opinion, let me know. But I think the part about to support a preliminary finding, right? So this is where my brain went. One of the first things that happens, right, is that there's a preliminary hearing. So if you think about Jarvis Butts, if you think about even ASAP Rocky, I attended his in person, right? There are these preliminary hearings that happen in front of a judge where evidence is put up, you get some testimony, and based off what, take the comment down. Based off of what is presented, the judge gets to, and it's a low bar, the judge gets to say, hey, there's enough here for this to keep going. You can keep this going. There's enough. So when I read that, my mind is basically saying that what Bev is saying is if the defense took what they have against Colin Albert, took what they had and tried, if he was to be charged, go with me here, there wouldn't be enough for a judge even to say, actually, there's enough evidence here for this to keep going. What she's saying, this is how I'm taking it. There's not enough here for this to even have passed the preliminary hearing stage to include him. And so I started thinking, while I think the whole Colin Albert part is hilarious, and y'all weigh in. I started thinking about what they actually have against him. We have that he is violent and thinks he's big and bad, which I agree. Okay, the man thinks he is. Okay, pull up, bitch. Bang, bang. Don't make me pull up the video. And when you go and think about that whole lawn thing, he threw some stuff on the lawn and there's a feud. And it was like, so the little boy has a feud with the grown man about his lawn and they took pictures. And when did it happen? When I personally was thinking about it, I was like, when you put it like that, when you put the like preliminary hearing part, I was like, actually, is that enough? So I'm curious. Now, I do believe that people act differently when they're around their people, right? So isolated in and of itself, is that enough? I don't think so. However, I think a young, hot-headed boy in the midst of his police officer uncles and in the midst of his big old German Shepherd dog, family dog, and all of that, could you get beside yourself and think you too big and bad? I could see that happening. But by itself, I was like, I don't know. I'm going to keep reading what she said, but I just wanted to, that's my initial thoughts, but I would love to hear y'all's. And Mary Thomas has one. But Mel, if there was evidence that had time to get rid of it because everyone loved to police about him being there. So they were, now you raise a good point. Why is everybody covering up if that boy was there or not? That I got a problem with. That I got a problem with. But even down to the knuckles, the time frame, it didn't feel like there was enough to like firm up when the knuckles happened. Am I misremembering? Y'all tell me. Khadijah saying, I'm all for the defense. He could have been overzealous. Bang Bang is definitely a liability to the family. You got to remember that the person who came forward about what actually happened is who said it was Colin and both Brian's. That's what made them look into him. That's true. That's true. The knuckle for, I think it was one of the best parts of the trial. But I was like, even at the end, I was trying to figure out who were they saying like did it? Who were the responsible people? I want him to be a part of it. I want the videos back in for my own selfish reasons. But in thinking about it, I was like, does she have a point? And I'm asking because, you know, I have my opinions about this chaos. Wait, Jessica Williams says Bang Bang was definitely up to some BS that night, whether it had to do with John or not. I agree. A lawyer told me it's about what you can prove, not about what happened. Well, that's the truth, honey. That right there. Brian Higgins got to know he's going to be the scapegoat for it. He should know. That's why I say the defense should just focus on the crappy evidence against Karen instead of trying to prove the third-party culprit. I will say this is my problem. Why is everybody trying to cover for that boy? Why is everybody like he wasn't there? He's left out of reports. He was picked up. Didn't know if you said hi or bye or what he. That I have a question. I got questions about, but that's all speculation. Like, do they actually have enough to lead you to where they're trying to take you? Oh, Sky is saying it was clear. It was clear to me who the defense believed did the crime. Shanika said, I just feel like that plus redoing the house, rehoming the dog, and moving is just weird. I agree. When you put everything together, I agree. But I agree. Well, so hold on. I'm talking Colin specifically. Everybody else, I got questions. But I'm talking Colin specifically. Okay. You're saying the fact that they mishandled evidence and lied, you feel like gives enough. Okay. It's a mess. It's a mess. But we gonna be in there. Are we not going to talk about the affair partner? The affair, the girl, that's out. I don't think they're going that route this time. You're talking about like the Brazil trip? If you're talking about the Brazil trip that the prosecution was trying to put on, which was dumb, where they had the girl come in and talk about they got caught making out or something, that I think is out, if that's what you're talking about. Come on, 5 months. Plus, one lady slipped up and said he was there. The blob lady. They need to pull all self-service data and text messages and FBI. See, you want it all. I agree. Christy, honestly, I think they knew that he knew about the Sandra Birchmore effery, and they wanted him to know they knew he knew, and they got out of control in their drunkenness and killed him. Okay, let me read a little more of what she says. It's hard to clean poop. Okay, I'm gonna make myself small so we can read a little bit more of what she's saying. Let me go here. Okay, so, I gotta pull it up. Okay, so I did that first one. The evidence of opportunity is wholly inadequate. So opportunity, now she's specifically talking about, did Colin have the opportunity to do it? There is no evidence that Colin was at 34 Fairview when the defendant and Mr. O'Keefe arrived at the home. So she's saying there is no evidence that he had the opportunity because there is no evidence that he was even there, is what she's saying, right? Evidence at the first trial was that Colin Albert had already been picked up by the time O'Keefe and the defendant arrived at 34 Fairview. Now, I think that this part is BS in particular because it was real. It didn't make sense. He arrived there, but then he left, and it was his cousin's birthday, but then didn't stay. Like that whole thing didn't sound. But that's her reasoning. So we'll move on. So opportunity, because remember what she said is that it has to go. Hold on. She said it's motive, intent, and opportunity. Those are our three. So she just hit on opportunity. He wasn't there. Now, motive, she says, as to the motive, the defendant contends that Colin Albert had been in a feud with John O'Keefe in the weeks and months leading up to John O'Keefe's death, and that Colin Albert had thrown beer cans on O'Keefe's lawn and swore at him. There was, however, no evidence substantiating these claims at the first trial. Even if there was evidence of some ill will between the two of them, motive alone is not enough to demonstrate third-party culpability. So just because you have a reason, that's not enough for you to use this defense. I will say it fell, I'm gonna be honest, it fell a little flat for me. The lawn thing, and I was chugging along, but it fell a little flat. So he hated him. He's also a teen. This is an adult. Like a lot of things happen in Kenton that are different than I'm used to. So it could work, but I was like, okay, trying to follow along. Again, I'm just talking about what was presented. I'm not talking about what I actually believe, because I believe he should be put up there, and I believe all the evidence against Colin should be included. I'm just kind of dissecting what she's saying, or trying to, because I'm not a lawyer. We'll keep going. Moreover, the theory that Colin Albert is a third-party culprit because he had scraped knuckles at some point after O'Keefe's death, had been seen in a video drunkenly taunting others with no connection to O'Keefe, and apparently was not named in police reports. See, that part is BS, and she knows it. It's speculative at best. Not named in the police reports, girl. Now, he should have been a part of the police reports. He just wasn't. You should have left that part out. We'll keep going. I'm skipping over some of the third-party culprit theory that victim was she's doing some law. Sorry, I'm just trying to move. Okay. Allowing such feeble third-party culprit evidence poses a risk of unfair prejudice to the Commonwealth and would only serve to confuse the jury. Accordingly, evidence that Colin Albert is a third-party culprit is excluded from the trial. The Commonwealth's motion in limine is allowed as to Colin Albert, meaning they can't use it against Colin. I'm just catching up on what y'all saying, because I'm just here to chat, okay? I was reading it and just was feeling away, because some of what she's saying, I'm like, girl, I don't agree. But also, was it shaky or was it not? And you know what the other problem I'm having, to your point, Tiffany? When you consider the story in totality, when you consider everything, when you isolate stuff like this, I see your point. It's like, oh, I see your point. But when you think about the full picture, I don't see your point. What you're saying is trashed. Talk on the Net says, I think a fight broke out. They didn't mean to kill John, panicked and left him to die. Shit got real fast, being drunk. But again, see, this is where I struggle, because again, why would this child be involved in this disagreement argument? Because I get the Brian Higgins connection and I get the Albert. I get those two. But why would the child be involved in this grown man dispute? Outside of him thinking he is a grown man and him being a hothead and him having too much to say, right? Like, sit down, little boy. Which I could see being the case. But that has always been hard. Like, why would this child get involved in these kind of brolicky, kind of officer guys scuffle? He didn't have no video games to go tend to or videos to make and show off his numbers. That part is a little weird. Is it weird? I need y'all be on my level, okay? Just take your brain there and tell me, was that an issue for you at all? He was a child, right? I mean, he was in high school. He hadn't graduated. I'm genuinely asking. Don't be here to fight me. I'm not calling. I ain't trying to fight. Okay, Joseph is saying because he's an unruly, drunk ass teenager. Okay, and you think that that is enough? That wasn't, and then I'm not being sarcastic. I'm being for real. I hope I'm coming across the way I intend. Let me make myself big so y'all can understand what I'm saying. Nancy is saying Colin was 17 at the time. He was drunk. We saw how he acts when he's drunk. He's a mess. Maybe it's just the way I was raised and the way I raised my children. It is hard for me to believe that a child is up in grown people business like that. That's where I'm struggling. But that's maybe just because of like my life experience. I was always told stay out of grown folks' business. And this is like real grown. And so the idea that he was this deep into grown folks' business is wild for me. Maybe that's why I'm struggling. Let me see. Somebody said he was what? Period. Let me get this off the screen before I get a lawsuit and I got to defend myself in court. Different POV. Colin may have jumped in if J.O. did something to Chloe. Did something to the dog? Thank you, Yvonne. That's what's happening. He was too much outside of a child's place that my brain is like, and they just let him. I could never stray too far out of the child's place that I was supposed to be in. And that's why I'm struggling. Colin is entitled and thinks he's a tough guy. Okay. All right. Okay. This ain't a regular child. Okay. He's drinking consistently, which also was like blowing my brain. People say, why hasn't anyone flipped about the conspiracy? But they are all related and involved. That's some of the things I've said too. It's family similar to gangs and the mob. Also, none of them were interrogated as suspects. So why flip? I guess what you're saying. Joseph is saying the video was enough for you to see him being a grown people business. That's essentially what I'm saying. Okay. She said, I'm a teacher. I can see it happening. I deal with these bad kids every day. No, you're good. That's a good point. Okay. You're opening my brain. Oh, Reddit says, ain't nobody going to like my opinion on this ruling, but it's correct. Is it? Okay. Cops for parents. He thinks he's above. I could go that angle. I really could. Y'all never been to a high school party where the parents supply the alcohol and it shows? Let me tell you what, I went to one high school party and I got caught. Okay. Cause I snuck there. Okay. So no. And the parties I was going to wasn't no adults. The alcohol was stolen. Or somebody's big sister brother brought it. That was not I didn't get to do that. Colin is not innocent. I've been at a red light next to him and he stares at everything. He's paranoid about something. Uh-oh. Star is here too. Star says it's the correct legal. Star, you're saying the correct legal opinion is that Colin should be excluded. And is it because of that preliminary, what she said about the preliminary finding? Like there's not enough for that? The family all seems to stick together. If dad or uncle or whoever was fighting, I'm sure he was in the middle. Would y'all? That's what I was about to say. I'm lying for my family. I don't care, so I can see they all being in on it. Okay. Y'all taking it. If your family is the Alberts, you get on that stand and saying the exact same thing. This is funny to me. That's true. That's you right, Lashana. You right. The area where I live, these type of teenagers absolutely be in grown people's business. Everybody in Canton is drunk. Why is that your comment? It's just everybody in Canton is drunk. Oh man. Drive safe, Tiffany. There's not enough to put before this jury. This is because of our friend 403 and 404. Yeah. Okay. So we can keep going. Oh, we're going to get to that one too, Nancy. I see you, girl. Everyone in Canton is drunk is also a valid legal opinion. I mean, based off their own testimony. The cops drink and drive, do MMA, and Colin following. I'm telling on my cousins, though, I don't care. They should do better. Okay, let's keep going because we're going to be here all night. And I just was, oh, okay, here we go. As to Brian Albert and Brian Higgins, the defendant's proffer is barely. Why'd she throw that shady word in there? She didn't have to say barely. Oh, let me make it big. I'm sorry. Why did Bev say barely? Was that necessary? Is barely sufficient. And the history of the first trial casts doubt on the seriousness of the claim. Why would she say that? However, to protect the defendant's right to a fair trial and in recognition of the fact that the defendant has no burden to prove anything under our law, the court will take the same incremental approach as it did the first time. Defense counsel are ordered not to mention potential third-party culprits in opening statements. So she's letting them use them because it barely passed, according to her. But they can't mention it in opening. They couldn't do it the first time either. But counsel will be allowed to develop the evidence at trial if possible, and counsel may seek an appropriate instruction if warranted after the evidence is concluded. The court knows that the defendant at the first trial under an identical order did not seek an instruction. Okay. Though the court may ultimately exclude the proposed third-party culprit evidence or counsel may abandon the theory, that does not mean the defendant cannot offer the evidence to show the inadequacy in the police investigation, provided that the proper foundation has been established. Hereby ordered, blah, blah, blah. It's allowed, meaning they can't talk about Colin in that way, but it's denied as to Brian and Brian, meaning they can, the defense can. Why? I don't know why she why she had to be shady. Because for her to say, and the history of the first trial casts doubt on the seriousness of the claim, she said, she just told them they're unserious. She said, y'all in this third party stuff is unserious. Get some business about yourself. Why would she say that? Well, so we're not going to get some of it, right? But we're gonna still be able to go with, well, we'll see, because like she said, they could abandon it, but it's seeming like we may, see some of the stuff that we saw the first time. But here's if you watch my debrief episode, you know how I feel. So I'm gonna do a poll. My poll is based on, let me tell you. Should the Karen Reed defense team abandon third party altogether and just reasonable doubt it? Or should they continue with third party culprit defense and show that these other people are responsible for John O'Keefe's death? I'm going to put a poll up. Don't ask me to do an option C because I'm not doing it. I want you to choose A or B. Okay? And yes, I know that's unfair and you have other opinions. I don't want them. I want your A or B. Okay, here we go. Should Karen Reed's defense team, option A is use third party culprit as a defense? Should Karen Reed's defense team only prove reasonable doubt? Hopefully this is a way that you understand the question. I should have just put poke holes. Because, and my concern is it confusing? Just like she said, right? It has to be done in a way that's not confusing. And my question is it confusing? And that's really what I'm getting at, why I'm asking, why I'm taking the poll. That's what I started to say this is a B conversation, see your way out, but I stopped because I didn't want to sound old. Well, so then the next one we're going to go is the Bowden defense, because she also had an order on that. And actually, let me pull it up. What happened? Okay, let me pull it up. And again, shout out to the people on X who post documents that I don't end up having to pay for, because you are appreciated. That's what I'm saying. We're not going to get pull up. And that's what I'm sad about. Why can't we get pull up? Why can't we get bang bang? Why can't we get that? I want it. I'm here for that. Oh, my internet acting up. It looks like a lot of y'all are saying poke holes and go reasonable doubt only. Bruh, why my thing not working? Hold on. Hold on. He is still on the witness. He still can be called. He can still be called. To be clear, right? This is not Judge Bev saying you cannot call Colin Albert to the stand. No. This is about the evidence that they are allowed to put in front of the jury. That's what that's about. And so the reason why I'm saying the bang bang and the knuckles is because that otherwise, right, those knuckles, right, would otherwise have nothing to do with John O'Keefe dying, except for the fact that the defense was saying he had knuckles shortly after this incident, proving he got into a fight with John O'Keefe on the night of the incident. Or the video of him saying, pull up, bang, bang, is going to show that he is violent or whatever. So outside of them being able to use that for the third party defense, it's otherwise excluded. It's not relevant. Okay. So let me look at what the poll is. 83%. Most people are saying, even though the third party is what many people believe is the truth, and a lot of, all of that, many people are at this point saying, girl, let it go and just poke holes. All right. So let's go to the Bowden, which the judge ruled on. Hold on, let me pull it up. Can y'all see that? Let me see. Oh, you know what? This happened last time because I don't be knowing how to make crap big. What it look like? Oh. Damn it, Gina. Hold on, because I want it to be big. Page 1. Page 2. What? Page 3. Give me a second. Sorry. Bruh. And then last page. Okay, I'm going to stop screen sharing, and then I'm going to do it this way. Hopefully so it's bigger. Okay, so this is the memorandum of decision and order on Commonwealth motion in limine to exclude defense's expert Michael Easter's opinion of the investigation. Okay, so the defense wanted Michael Easter, this former FBI, I think it was FBI agent, to basically give his thoughts and opinions on the quality of the investigation, right? That the police did for this case. They wanted him to get up there and basically say, they did a terrible job. This is not protocol. This is not, it's not reliable. This is trash, is what they wanted. The Commonwealth was like, no. We don't want that man to get up there and say that. Everybody relax. Okay. And so this is Judge Canoni's ruling, her ruling on this happening, on the motion. Defendants have the right to base their defense, blah, 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 on the failure of police adequately have the right to base their defense on the failure of police adequately to investigate in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. So it's basically as a defendant, you can say this investigation by police was so trash that it's enough for you to believe anybody else could have done this because they didn't even do a good job, right? That's essentially what's happening. To support a so-called Bowden defense, a defendant may present evidence that certain tests were not conducted, certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated. We see this all the time in trials, right? In circumstances in which it was reasonable to expect that the police should have conducted the tests, followed the procedures, or investigated such information, right? Yeah, I was going to say, it's weird. Stara is saying, it's crazy to me you have to plead a Bowden defense. Here it's just like what we do. That's why I was saying we see this so often that it's weird that it has to be like something that you're pleading versus, I mean, it was all up and through the YSL case. And it was just constantly going at, it's in my mind, and I'm not a lawyer, in my mind, it's every defense attorney is going to go that route regardless. Like in my mind, the first thing you're going to do is attack the way police did the investigation. You have other points, but like that's a given. So it is weird. But I'm not a lawyer, so what do I know? In my very non-existent years of experience as an attorney, this is very weird. Here we go. An expert, when appropriate, an expert may, when appropriate, be used to support a Bowden defense on matters beyond the common knowledge of the jurors. I don't know why this keeps doing this. The role of expert testimony is to assist jurors in interpreting evidence that lies outside of their common sense, right? So that is her setup. I have to go to find page 2 now, since it's all individual. Bear with me, people. So let's go to page 2. I don't want to read the whole thing. I'm gonna skip to here. In support of her Bowden defense, the defendant here. Oh, let me take your comment now. In support of her Bowden defense, the defendant here seeks to admit expert testimony from Michael Easter, a retired agent of the FBI, to opine on law enforcement's failure to adhere to standard investigative policies and protocols in this case. So they really they're asking, the defense was like, hey, we have this retired FBI agent who's going to talk about how terrible this investigation was, how they didn't even do the basics of what's required. More specifically, Easter's expert report indicates that he will testify that the investigation in this case was not reliable due to the lack of secured crime scene, absence of a detailed crime scene log or evidence chain of custody, the failure to separate witnesses, and the premature categorization, of individuals as witnesses, and potentially biased based on the failure to investigate other suspects and obtain their cell phone records. So they were going to have him come up there and talk about all of that, right? That they didn't secure the crime scene, that they didn't have the evidence log, a chain of custody. They didn't separate the witnesses, even though they're family, and the body was found on the front lawn. And how they determined people were witnesses before even allowing them to be considered as suspects. He was going to get up there and tear them apart. And so I'm going to skip some of this because I don't think we need to read all of that. I think we get the point. And I think my point is clear. So I'm going to go to page 3. Amen. Because it's my live and I can do what I want. So I'm going to skip to here. Easter's proposed testimony concerns basic aspects of a police investigation, which are within the common knowledge of a lay person. So she's saying what he's going to talk about, like most people already get. Through zealous cross-examination of police witnesses, the defendant, let me keep reading. The defendant can cast doubt on the reliability of the investigation by demonstrating how it differed from standard practices and procedures, and can raise the issue of potential bias by police action or inaction, as counsel did effectively during the first trial. So she is saying the first trial, y'all didn't have him and y'all were just fine. Y'all were able to ask questions that showed that this investigation was trash. I'm going to skip over her. Okay. The court finds that expert testimony is not needed for the jury to determine whether or not the investigation was compromised by any failure to follow procedures or pursue other suspects. Blah, blah, blah. The defendant is undoubtedly permitted to pursue a Bowden defense, and the court will give the jury a Bowden instruction if requested. However, jurors are perfectly qualified. Remember that last part. Jurors are perfectly qualified to evaluate the adequacy of the police investigation, in this case, without the assistance of expert testimony as proffered by the defendant, right? So she basically is saying, no, you can't have an expert, but you don't need an expert because this is so bad that everybody can tell that it was bad. So I'm telling you no expert, but I'm also saying that it's clear that this is terrible. So that's what she's saying. That's her ruling. I feel like, girl, if it's that bad, well, then what's the problem in letting the expert testify that it's bad? I mean, we already got how many witnesses on the stand witness list? A lot. So what's one more? So she is not letting this expert, former FBI agent say that this is a terrible investigation because basically everybody can tell that it's bad. That's how I took it. Star is saying she's never heard of an expert like this. I don't see the harm. What's the harm? Why can't our people come talk about how bad it is? And then let me find the witness list, because the combined witness list got put up today. And I'm like, you guys, this trial is going to last so long. I cannot even wait. Star says she gets why she ruled this way, but it's too much to type. I think they need to. Where did your comment go? I missed your comment that I was trying to find. Okay. She just trying to save time because she done already did this one time already. Yeah, I don't, it just feels like, why not, if you're really going after the investigation, why not be able to like put that up? Especially, here's where my brain goes. Which I'm sure this is not able to be. This is my layperson brain, right? That the FBI is an organization that, like most people, I mean, outside of some of the chaos of today's world, but the FBI is an organization that most Americans generally respect. I think maybe that's too much of a generalization, but I feel like it's like, oh, the feds, you know? And so I say that to say it comes with a bit of authority. And so to think that somebody from the feds is coming on and able to like rip apart or opine or give their opinion on an investigation, me personally, I would feel comfortable trusting that expert, probably simply because of the FBI tag. Maybe that's not even appropriate, but that's the way I would think about it. Like, oh shoot, if they're saying it was bad, like it must be because they are together. So anyway, I don't know. I cannot wait for this trial to just do whatever the hell it's going to do. Because yeah. What's the thing at? Okay, so we stayed around 84, 83, 82. A lot of people are saying that she should really focus on reasonable doubt. So, well, we're not going to, tomorrow is jury selection day 1, but we're not going to get a ton of anything until the jury is selected, which is going to take weeks. So even though we'll all be waiting with bated breath, it'll be quiet on that end for a while. So everything is right starting tomorrow. But again, jury selection is not something that is filmed, right? So you won't be able to see it. You won't, there will be no cameras in there getting the jury, that process. And again, it's supposed to take weeks. So even though it's starting tomorrow, right? Like when a trial starts, it's always jury selection first, depending on how long that process takes. And this trial has only gotten bigger since the first time. It's only grown. So being able to find a fair and impartial jury is going to take a while. Okay. Star is going to voice note me. So that's that. There also is another trial that's expected to start tomorrow, the jury selection process. That is the Lori, right? Lori, what's her last name? Oh, Nancy. Let me say this while I'm thinking about Lori's last name, DeVoe or something. I have two vacations scheduled during this Karen Reed trial. So when you see me, so when I'm not watching, just know I'm somewhere on vacation pissed off. I'm going to be on vacation thinking about Karen Reed's trial. Valo, thank you. Oh, Yates isn't here. Okay. So I need to get caught up on that because she's defending herself. Y'all, you know how we feel about people defending themselves. And I don't know enough about it. I did some light situations, but I don't know enough about this trial. But I'm hoping that it starts before Karen Reed, so at least we have something to kind of catch up in, get caught up in while we're waiting for Karen Reed, since that it's going to take weeks. But I also don't know how long Lori's trial is going to take. Oh, people are saying, okay. Oh, nice. I love that. It's a good little encouragement, right? Did you listen to it on the beach? That's going to be me. I'll be a defendant representing themselves on trial is a time. Anyway, well, that's all I really wanted. I wanted to talk about this Karen Reed stuff because I just have all the feels about it. And I'm ready for the trial to start. There was one more thing I was going to raise. I don't remember. Anyway. Can people considered property by law defend themselves against people? I don't understand your question. Can you say it again? Can you type it again? Oh, if Lori's one, you gotta pull up to court. Go sit in the audience and tap in for me. Oh, I'm a court reporter. I've had a few pro se defendants try. Oh, I'm sure. I am sure. Those are always a time. All right. I'm just making sure I didn't miss anything. All right, people. I watched it with EDB in the sun while she was losing her mind. Wait, which one are you talking about? Are you talking about the old Karen Reed 1.0 you watched? Okay. Did you text me and I missed it? Oh, good. Okay. I'll be caught up in. Oh, if she gives Sarah Boone vibes, that's enough context for me. I'm going to be watching. I can't. Although I'm hoping if it takes, let's call it 3 or 4 weeks, it'll at least be, if Karen starts after my first vacation, then that it's better for me. It's I can manage my second vacation, but my first vacation was with my kids and I'm not going to be able to be tapped in. So I needed to take at least 3 weeks, but if it took like 5, that would be great. Oh, yes. I don't understand what you mean. Can people deemed as property? If a person is considered property, like if you're a person, but for some reason you're not a person, you're property. That's the way I'm reading this question. Defend themselves by America. Like, can my couch over here defend themselves? That's how I'm reading it. Oh, are you trolling me? That happens too sometimes. Okay. All right. Oh, he said, yes, how black people are seen as property. So, like, can a black person who is otherwise considered property defend themselves? Constitutionally, yes, because we're not property, we're people, but slaves. Can slaves defend themselves? Look, I got all the okay, I'm gonna let y'all go for real, but I got all the compliments on my nails. They're so bright and I love them. I love everything about them. Okay. All right. This was a random live. I appreciate y'all popping in here to talk Karen Read with me. Maybe we'll do. Oh, I'm supposed to be. Should I announce this? I should be joining AV to the Seventh Power soon. So just be on the lookout for that. I'm going to be joining one of her lives. So just be on the lookout for that. We're in talks of trying to figure something out. Thanks for hopping in here really quickly. Y'all have a good Monday. I guess it's evening now on the East Coast. So make sure you like. Yes, like, subscribe. I didn't turn the subscribe thing only. Make sure you subscribe. Okay, bye. Bye, bye, bye. Ain't no, here it is. You see it? Cause it ain't no lie, baby. Okay, bye.